Hello and welcome to Rajya Sabha TV. I am Raj Kamal Rao. Today we will bring to you a special report on the Undisclosed Foreign Assets and Income Imposition of Taxes Bill 2015. Black money refers to money that is earned illegally. Black money also includes transactions made in tax havens like Cayman Islands and Mauritius. Domestically, black money is in large circulation in areas like real estate and gold transportation. There is no official estimate as to how much Indian money is illegally transferred abroad. While there is no definitive study, there are claims by various bodies and individuals that the quantum of black money could go up to $1.4 trillion. The US-based think tank Global Financial Integrity thinks it could be in the tune of $462 billion.
This figure does not take into account hawala, it does not take into account narcotic drug trafficking, it does not take into account human trafficking, it does not take into account other such criminal activities. So this is a gross underestimate.
If you are able to get, say, from Edward Snowden, the entirety of the transactions entered into by the Indian residents here in regard to the deposits in foreign countries, even if those accounts have been cleared or cleaned out, it makes no difference. You get the material, the bankers' accounts will be believed, it can be treated as evidence of the existence of those assets, which are no more present in those banks. But you can proceed against the properties.
जिस दिन भारतीय जनता पार्टी को मौका मिलेगा, एक पाई हिंदुस्तान की वापस लाई जाएगी और हिंदुस्तान के गरीबों के लिए काम लाई जाएगी.
In 2011, when it was in opposition, the ruling Bharatiya Janata Party claimed that black money in India was between 500 billion to 1.4 trillion. The party campaigned vigorously on this issue during Lok Sabha elections.
दुनिया के किसी भी देश में हिंदुस्तान का पैसा रखा गया है. अगर आप मुझे आशीर्वाद देंगे, मौका देंगे, मैं पाई वापस लाऊंगा.
The rhetoric reached its peak at election rallies, not only promising to bring black money back to India, but also to distribute it to the tune of 15 lakh rupees for each Indian.
एक गरीब के परिवार में 5 लोग हैं तो 15 लाख रुपया उसके घर में आ सकता है. इतनी बड़ी धनराशि विदेशी बैंकों में जमा है.
Every right-thinking government has come forward in their manifestos by declaring that they will put down black money. And black money is not the problem of foreign banks alone, created by foreign banks. It is, I think, rampant in this country.
See, it's mostly a political implication in the sense that they made a promise, they have to make a noise about it, and there are two parts to all this black money business. One is the domestic part, where it's circulated, it is generated, it is injected from outside through the drug mafia and so on. And then it is applied also to all kinds of purposes which try to make white out of black and things. So that process of generation, circulation is something government seems to be totally silent on.
Indian and foreign news agencies are collecting data from various sources, but they have given contradicting numbers on black money holders.
These types of tax havens, the banks over a period of time, under the secrecy clauses, they don't want to know who is the person. They only want to keep the money there. So therefore, the banks themselves are going to have some unknown names, unknown shell companies, etc. So disclosure of that per se may not. But if they give address, it is not difficult to trace.
If you were to ask Switzerland or a Swiss bank, how much of Arun Kumar's money is there? They'd say Arun Kumar doesn't have an account because my money has been transferred from Jersey Island in the name of, say, some company called Crocodile. So Crocodile from Jersey Island has invested in the bank in Switzerland. And therefore, the Swiss government will legitimately say Arun Kumar's money is not there. Arun Kumar is an Indian, but this company is a British company.
So far, officially, government gave a list of 628 alleged black money holders in a sealed envelope to Special Investigation Team. These individuals were reported to the Indian government in 2011 by the French authorities. All of them have accounts in HSBC's Swiss banking arm in Geneva. Of these, 428 were found to be auctionable cases.
That the complete list of US depositors have been disclosed to the US government. We have HSBC functioning in India. Therefore, it is open to us to put the same pressure or throw them out of this country. They cannot continue this system anymore. It is time that they close down this numbered accounts, this secrecy in regard to the banking deposits, because most of these deposits are obviously the result of crimes.
The HSBC list is part of a global collaboration that saw 140 journalists go through a list of Swiss bank accounts obtained by Paris-based newspaper Le Monde. It included names of several corporate heads, politicians and NRIs. The bill makes provision for 90% penalty on the money stashed abroad or the value of the asset which is there on foreign country. It also makes rigorous provisions for an imprisonment up to 10 years for willful attempt to evade taxes on the foreign income. Hiding tax evaded money abroad will now be a criminal offence. Those who evade taxes and stash money or assets abroad may end behind bars. The government has introduced a new law to curb hoarding of black money in foreign countries. The government believes that tax evasion puts disproportionate burden on honest taxpayers and robs critical financial resources meant for social inclusion and economic development.
They are trying to catch hold of or address those people who have assets or income in the foreign countries and who never disclose them to income tax department. So this is showing the seriousness of the government that they want to attack the black money in all its force.
Reduce the banking secrecy, like for instance in the HSBC case. HSBC was acting as a hawala operator.
Yes.
It was providing the facility for Indians to give it rupees, which it would deposit as dollars in the Swiss bank account, and then bring the dollars back to India and give rupees back to this gentleman whenever he wanted. So this has been established. The income tax authorities, after they raided some people, they got all this information. This has come out in the press. So not only HSBC, but large number of other multinational banks and Indian private banks have been operating as hawala operators in India for the last 20 years. So this bill should have done something to curtail this banking secrecy.
According to the Undisclosed Foreign Income Assets Imposition of Tax Bill 2015, tax evasion will now be categorized as criminal offence. Provisions of the bill will apply to all persons residing in India and holding undisclosed foreign income and assets. The bill proposes to impose 90% of the undisclosed income or value of asset as penalty on willful defaulters with rigorous imprisonment from 3 years up to 10 years. Any failure to furnish details of returns on foreign asset or furnishing inaccurate particulars of foreign assets will be punishable with rigorous imprisonment for a term of 6 months to 7 years and a fine of 10 lakh rupees. Second and subsequent offence will be punishable with rigorous imprisonment for a term of 3 years up to 10 years and with a fine of up to 1 crore rupees. These provisions will also apply to banks and financial institutions supporting in concealment of foreign income or assets of a resident Indian.
The income tax department is well versed as of adjudication processes, appeal and settlement, etc. So those processes should necessarily be borrowed for implementing this law. There is no difficulty. Just because the existing income tax provision or the appellate authorities are being used for implementing this, that doesn't mean that it is the old wine, new bottle. It is a new wine, new bottle.
The bill also proposes to amend the Prevention of Money Laundering Act PMLA 2002 to include offence of tax evasion under the proposed legislation. The bill empowers the central government to enter into agreements with other countries, specified territories and associations outside India for exchange of information, recovery of tax and avoidance of double taxation.
What is the double taxation avoidance agreement? It says that if an Indian national has an income in Switzerland and in India, then it will be taxed only in either Switzerland or in India. But this is about declared income. But if I am not declaring my income, then no tax is paid either in Switzerland or in India. Therefore, you know, how would that be captured in the double taxation avoidance agreement? And we've had double taxation avoidance agreement for a couple of decades now, but not one bit of information has come in the last couple of decades. Because it's not about your illegitimate income, it's only about your legitimate income. So double taxation avoidance agreement also cannot get any fresh information about the black incomes of Indians.
Voluntary disclosure of black money can result in a lesser penalty, and those who do it will be saved from prosecution. The government proposes a window of opportunity for foreign account holders by allowing them to pay 30% of the tax instead of the 90%. But the taxes paid under the voluntary disclosure team will not be refundable.
They also give certain windows for a short period whereby you come and voluntarily disclose those. Instead of we finding out, you come and tell us. If you do so, you'll still pay 30% tax, but you don't pay 300% penalty, pay 100% penalty.
The Undisclosed Foreign Income and Assets Imposition of Tax Bill allows persons having undisclosed foreign assets to file a declaration before the income tax authority. Government intends to allow an opportunity for citizens to become tax compliant before the stringent provisions of the new legislation come into force.
It will not come into force till the 1st of April 2016. Now that gives you a period, a window, where any prudent tax evader who has undisclosed income abroad would have the right to go under the Income Tax Act and disclose the monies that he has abroad, the income which he has concealed from the tax authorities over a period of years. Now with this, he will be subjected only to the penalties, etc., under the Income Tax Act, not the more draconian or the more severe punishments under the present law.
Under this law, there will be a flat rate of 30% tax and a 300% penalty for undisclosure. So this is the norm, and therefore, and apart from this, criminal prosecution of the people. So this is showing the seriousness of the government that they want to attack the black money in all its force.
According to the bill, exemptions, deductions and carried forward losses will not be allowed under the new legislation. Upon filing these conditions, a person will not be prosecuted under the declaration, and the declaration made by him will not be used as an evidence against him under the Wealth Tax Act, the Foreign Exchange Management (FIMA) and the Companies Act or the Customs Act. Wealth tax will also not be imposed on any disclosed asset. Persons holding foreign accounts with minor balances which may not have been reported out of an oversight have been protected from the criminal consequences. To facilitate inquiry and investigation, authorities under the existing law are empowered to inspect and issue commissions. In order to safeguard against misuse of proposed law, it will not be mandatory to issue notices and grant opportunity of being heard. Record reasons for various actions and pass written orders. Appeal to Income Tax Appellate Tribunal and to the Jurisdictional High Court and the Supreme Court on substantial questions of law have also been provided for the proposed legislation. Any appeal before the High Court will be heard by a bench of not less than 2 judges of the High Court.
Think of at least 2 parts where something could be done in terms of investigation. One is for the external part, the participatory money routes, the participatory note route to the investments by FDIs. This is something that the previous Governor of Reserve Bank, Y.V. Reddy, had fought tooth and nail, but he fought a losing battle because the Finance Ministry was only interested in the stock market rising. But he had insisted that the registered FDIs, if they are taking participatory notes from somebody else, then there has to be a full disclosure of who those persons really are. And even if they give false names, I'm sure internationally today there are enough protocols of cooperation between governments to be able to track who has given a fraud name.
By passing a bill within the country, what are we doing? We are saying that those Indians who have taken their money out, they will be asked to bring it back. By the threat of this bill, that there'll be heavy prosecution, there'll be jail term, there'll be heavy fines and so on. But the question is, when the money goes out, how can you track that money going out?
The passage of the bill is likely to enable central government to tax undisclosed foreign income and assets and punish the persons indulging in illegitimate means of generating money, causing loss to the revenue. It will also prevent illegitimate income and assets kept outside the country from being utilized in ways which are detrimental to the India's social, economic and strategic interests and its national security.
This bill, if it was serious, would have made provisions for tracking these things, so that the money going abroad could be tracked and where it's finally deposited could be actually captured.
It's time for us to head into a break. When we come back, we'll tell you about the provision that gives limited relief from prosecution, which is mentioned in the bill. Welcome back. The special investigation team appointed by Supreme Court wants the government to expedite all pending cases under income tax law to curb domestic black money. SIT also wants the government to put a cap on the cash that an individual or an entity can possess at a particular time. The Supreme Court set up the special investigation team on a petition filed by Advocate Ram Jethmalani. It was given the task of investigating unaccounted money that's banked outside India and suggest steps to bring it back to India.
I think we should give credit to Mr. Ram Jethmalani, who is a man who fought out a case. He himself, as party in person, filed the writ petition in the Supreme Court of India. The division bench of the Supreme Court took up the matter and have passed very stringent orders. And I believe that so far as the Supreme Court is concerned, they should get the credit for taking the first step forwards.
Retired Justice M.B. Shah was appointed as the chairperson. Apart from eminent jurists, the SIT includes Secretary Revenue, Deputy Governor of Reserve Bank of India, Intelligence Bureau Chief, Intelligence Bureau Director, Director of Enforcement Directorate, and Director of Central Bureau of Investigation, Chairman of CBDT, and the Director of Research and Analysis Wing RAW. Submitting its first report on black money, the special investigation team made some suggestions to the government. It recommended setting up of 5 courts in Mumbai to speed up 5,000 odd pending income tax cases. Further, it sought tax evasion included as a scheduled offence under the Prevention of Money Laundering Act. The team also asked for changes in the Foreign Exchange Management Act to allow authorities to seize and confiscate properties of violators. The last suggestion was to authorize to tally import and export data with foreign governments in order to keep tabs on the trade-based money laundering. The SIT recommended a cap on the maximum cash an individual or an entity is allowed to possess at a particular time. Forming the special investigation team was the first decision taken by Modi government when his government took charge. Narendra Modi has been campaigning to bring black money back even before elections while he was on the campaign trail. In the first official meeting of the NDA government, Law and Telecom Minister Ravi Shankar Prasad announced the formation of the Special Investigation Team.
ये हमारे लिए बहुत संतोष का विषय है कि आज जब श्री नरेंद्र मोदी की अगुवाई में सरकार की कैबिनेट की पहली मीटिंग थी, तो विदेशों में जमा ब्लैक मनी के बारे में सार्थक कार्रवाई करने के लिए हमने सुप्रीम कोर्ट के आदेश के आलोक में SIT को कॉन्स्टिट्यूट किया है.
The Modi government has been trying hard to strike bilateral agreements with tax haven nations in order to get details of Indian account holders who evaded domestic taxes. Finance Minister Arun Jaitley also wrote to individual banks on these matters, but so far none of them showed much interest in disclosing details of customers.
It is easy for them to say, come forward and prove that these deposits are all illegal. Now they know that it is a very, very difficult task for any country to be able to produce sufficient evidence before the banks to show that it is ill-gotten gains or wrongfully acquired properties or monies.
Why would a bank reveal data automatically? Unless you ask. And therefore, you have to have prior information that such and such account, actually the actual beneficent owner is somebody in India by this name. then you can ask that this account be revealed because the beneficial owner is somebody else.
What does the Swiss bank say? They say, bring a case against somebody for something which you are investigating, maybe even a murder, maybe a property dispute, maybe anything in which the government of India is involved in investigating it, and we will cooperate in that investigation. But without a case against the guy, I am not going to generally respond to your queries about what is my database and what does it say.
Those who are not and who are actually transgress the law, the information may come 6 months down, 2 years down the line, but the legislation is in place, and they will be really punished with the most stringent condition as per the law is concerned.
Recently, Jaitley told Lok Sabha that government completed an assessment of 350 foreign accounts. It also initiated tax evasion proceedings against 60 account holders
who want to deposit their monies in Swiss bank accounts and other tax havens have developed a feeling of confidence that the government will not do anything about it, nor would it be possible for the government to be able to extract from the banks the identity of the depositors. It is this confidence which has resulted in the accumulation of mind-boggling amounts in foreign tax havens.
A total balance in these accounts is reported to be 25,420 crore rupees, nearly 5 times the amount under investigation. The government also promised the court that by March 31st, 2015, it will complete prosecution of illegal account holders in the first batch of 628 names.
Deadline for completion of all investigation and assessments under the Income Tax Act in all these cases is 31st of March 2015, by which time it has to be completed.
The government has already recovered substantial amounts as penalty for tax evasion from over 300 Indians with Swiss bank accounts. The bill needs to be passed by both the houses of the parliament and notified by President to become a full-fledged law. That's all we have time for in this special edition of Special Report. We will be back with a new issue and a new report. Keep watching Rajya Sabha TV.